Welcome to Deep Dive with the Institute for Justice. I'm Melanie Hildreth, and I'm here today with IJ President and General Counsel Scott Bullock and IJ Senior Attorney Bob McNamara. We're going to talk today about immunity. So immunity is a term that's probably familiar to Deep Dive listeners who have also listened to IJ's podcast, Short Circuit. It comes up a lot when they're talking about cases where someone feels that the government or a government official has violated their rights, and they're going to the court and asking the court to hold that person accountable. For people who aren't familiar with immunity and the way that it plays out in those cases, Scott, do you mind starting us off with a little primer?
Sure. I should probably start off by reminding folks of how difficult it is to sue the government in general. And this is true for even our most basic cases that we do at the Institute for Justice when we sue for what's called declaratory and injunctive relief. And that's basically when you're just asking a court to declare that what the government is doing is unconstitutional and to enjoin them, to stop them from enforcing that law. Because there's all kinds of things you have to overcome. The government has a presumption of constitutionality that works in its favor. They, of course, have the deep pockets of the taxpayer to draw upon. So it makes it very difficult for the average citizen to sue the government. And it's one of the reasons why a group like the Institute for Justice exists. It's one of the only ways that a person has to really vindicate their rights. On top of that is the doctrine of immunity, which makes it, in many instances, almost insurmountable for people to hold government accountable and to get monetary damages, even when the government egregiously violates their rights. And there's all kinds of different doctrines of immunity. There's absolute immunity that typically applies to judges and unfortunately to prosecutors. And then there's the doctrine of qualified immunity, which is what probably a lot of people are familiar with, which also makes it extremely difficult for citizens to hold government officials accountable. And this is very different than what private citizens face. If you violate someone's rights or you hurt them in some way, you are held accountable for it as just an average citizen. Not the case with the government. Government officials have immunity, and citizens then have to overcome that immunity. And so that's one of the reasons why we launched IJ's project on immunity and accountability. And it starts with a very simple but fundamental premise that if citizens must follow the law, which government always is reminding us citizens are obligated to follow the law, then government officials must follow the Constitution. And if they don't, they have to be held accountable for it.
The idea that a government official could be completely immune or even partially immune, for most people will probably sound kind of crazy in a government and in a system where the framers were clearly so conscientious about setting up checks and balances and other ways to kind of limit government's ability to infringe on people's rights.
Well, it's right. I mean, there's the immunity doctrines are nowhere in the Constitution. They're basically judge-created doctrines that shield government officials from accountability, but you won't find it mentioned anywhere in the Constitution and really not in any laws. And many laws, like Section 1983 that some people might be familiar with, actually give a right to citizens to sue the government to hold them accountable.
So if it's not in the Constitution, it's not in the law, and in fact, the opposite's in the law, where did this idea come from? How are we in the place where we are now?
I mean, it comes from the courts. I mean, the modern doctrine of qualified immunity really starts in the early 1980s in this case called Harlow v. Fitzgerald. And the plaintiff in that case had alleged sort of a vague, shadowy conspiracy. He was a government employee and said that a bunch of figures in the Nixon administration were conspiring with each other to prevent him from continuing in his job. And the court is clearly uncomfortable with kind of the vagueness of the conspiracy that's being alleged. But the court also says, look, even if all of this is true, it's not totally clear to us whether this sort of activity is illegal in the first place, and we're not going to hold someone liable unless the constitutional rule they violated was clearly established. And in a certain sense, I think framed at that level of abstraction, the idea of qualified immunity appeals to a lot of people. If the Supreme Court is going to announce a brand new rule for the first time, it seems kind of unfair to say you're going to be liable for breaking this rule that literally no one knew about until we announced it just now. But that's not really what the doctrine means in practice.
Right. So how does it play out? There's some pretty crazy stories of how this works for the average person interacting with government officials. rules.
Right. And so what the doctrine has morphed into since the 1980s is not just we're going to let you off the hook if we announce a brand new rule you couldn't possibly have known about. What it's morphed into is this idea that for a rule to be clearly established, you have to find a federal appellate case saying that exactly the conduct the government official engaged in exactly the circumstances he engaged in it in, was unconstitutional. And if you don't have a case on point, the law can't be clearly established, and therefore you're entitled to qualified immunity. And it leads to absurd results. There was one qualified immunity case where it was clearly established. There was an earlier appellate case that had held it was unconstitutional for the police to sick a dog on a surrendering suspect. And so someone else sued and said, well, I was surrendering and the police sicked their dog on me. And the appellate court actually said, well, the first guy was lying down and you were seated with your hands in the air. And those are just different circumstances. And so the police are entitled to qualified immunity.